Today we will be hearing from Leigh Riley, Kathy Aizawa, and Ryan Parsons. Leigh focuses her practice on employee benefits and executive compensation, counseling both private and public companies on all types of benefit plans. Kathy focuses her practice on employee benefits, including health and welfare plans, pension plans, and executive deferred compensation plans for tax-exempt governmental employers. Finally, Ryan represents and counsels employers in all aspects of the employment relationship, with particular focus on management-side labor relations, including the handling of discrimination and harassment matters. He also focuses his practice on complex employee benefit litigation and appellate matters. With that, I would like to turn today's presentation over to Leigh Riley.
Thanks, Kayla. So for today's presentation, we're going to talk about three different topics for you. We're going to start off with hidden ERISA plans. Kathy will then talk about record retention requirements for benefits. And on the second one, it's a topic we want to discuss because we've just gotten a variety of questions lately from our clients about this issue. And then Ryan is going to finish the program talking about investigating MeToo harassment allegations. So starting with hidden ERISA plans, and what do I mean by that? So a hidden ERISA plan is a benefit program that an employer establishes and they don't even realize it's subject to ERISA. You might think of these also as an accidental ERISA plan, which is an offer to benefit and oops, I didn't even realize it was subject to ERISA. Normally we see these hidden ERISA plans come up in the context of welfare benefits. It's rare to see a situation where an employer has a retirement program and they don't realize that that retirement program is subject to ERISA. Although I will tell you, I have seen that come up once where an employer had what they thought as a severance arrangement, but they said if you retire on or after 55 with 10 years of service, you automatically get severance. And they were a little surprised to learn that that was actually an ERISA retirement plan. But other than those very rare situations, this does come up quite a lot in the welfare plan context. And as a refresher, on the screen, you'll see the different types of welfare benefits that can be covered by ERISA. Most of these are no surprise to you guys, medical, sickness, accident, disability. But the ones on the right, including severance, you may not have realized. So what do we normally hear from clients when we're on the phone with them and they're talking about a benefit program and we say, oh, you realize that that benefit program you're implementing is subject to ERISA? Typical response is, ugh, are you kidding me? I hate ERISA. ERISA carries all these requirements that I just don't want to deal with. That means I have to have a summary plan description for this benefit arrangement. I also have to do 5500s if this plan covers more than 100 participants. And now, Leigh, you're telling me I've got all these fiduciary duties relating to this program. And if I don't do my summary plan description and my 5500 and my fiduciary duties, then I realize I'm going to be subject to penalties or possibly risk of lawsuit. Clients say, ugh, I don't want to deal with all this stuff. But then what we normally say is, well, not so fast. There are parts of ERISA that are really good, especially when you're starting to get in litigation situations. For example, ERISA preempts state law. So if you ever get sued about an ERISA program, the only thing the participant can ask for is the benefits due under the plan and maybe their attorney's fees. But there's no other damages involved in a lawsuit relating to an ERISA plan. No punitives, no double damages, which you often find under state law. Also, as you guys know, ERISA says that plans have to have an internal claims and appeals process. And so if somebody is unhappy with a benefits decision, they have to let you know about that through the claims and appeals process, and that gives you an ability to work out any issue instead of them running directly to court to file a lawsuit. Also, it's well established now that ERISA plans can have a statute of limitations. In other words, you can put in your document, If you want to file a lawsuit about this issue, you have to file the lawsuit within 1 year of the date your benefit was denied. And that gets you out of state statute of limitations, which sometimes can go for 6 or even 10 years. In addition, courts give a lot of deference to plan administrator decisions. So whatever the plan administrator decides typically is upheld by a court unless it's very unreasonable. And finally, there's no rights to a jury trial. It means a judge is going to make the decision, and as any litigator will tell you, sometimes juries can come up with some unbelievable decisions that they shouldn't. So we like typically to avoid jury trial. So that's the tension with all of these, right? There's good things about ERISA, but there's bad things about ERISA. And one of the issues then is just trying to identify which plans do you have that are subject to these rules. So I'm going to now go through what the 4 typical types of what I call the usual suspects, things that come up over and over again in conversation that people are often surprised are ERISA plans. So first are wellness and EAPs. So as you know, as you saw from the slide earlier, ERISA covers health plans. But a health plan is defined not just as a plan that pays for medical care, but also that one that provides medical care. And we very often see in wellness programs that medical care is being provided. Now, not a lot of medical care. It's like a little itty-bitty baby health plan in some instances, but there are wellness programs where things like biometric screenings are being offered. And if you think about what is a biometric screening, I get my blood pressure and my weight and blood drawn, and it all goes and gets tested, and the results are given back to me. That's very much what happens when you go to visit your general practitioner, and that in and of itself can be a health benefit that puts your wellness program into ERISA. In contrast, wellness programs that do things like lunch and learns or fitness challenges, those aren't providing medical care, so those wouldn't be subject to ERISA. EAPs have a similar situation. So an employee assistance program may have a provision in it that says you get 3 mental health counseling sessions through the EAP. Those 3 sessions right there turns that EAP into an ERISA health plan. Again, in contrast, if the only thing the EAP vendor is doing is serving as a referral to other physicians, say that the EAP, if you call them up, helps you find a psychologist that's under the regular big group health plan, and they just help you make that appointment, that would not make the EAP a health plan. Usual suspect number 2, on-site clinics and telemedicine. So these are ones where we are seeing a lot of our clients show a lot of interest in providing these types of healthcare benefits because it keeps costs down and it's convenient for employees. And similar to the wellness and the EAPs, a lot of employers just don't think about these as ERISA plans because, again, an ERISA health plan is one where I go to a doctor, they file a claim, the plan pays the claim. Well, that's an ERISA health plan, right? And again, no. An ERISA health plan can be an arrangement where you are directly providing medical care. And that's exactly what on-site clinics and telemedicine arrangements are doing. Now, in ERISA, there is a very narrow exemption for on-site clinics if the care is limited to first aid for work-related injuries or treatment of minor illnesses or injuries. Kind of like the on-site clinic is just maybe a nurse, and he or she is just there to handle things as they come up. In our experience, though, most on-site clinics go well beyond these types of services, and they have physicians on staff and nurse practitioners on staff, and they provide a wide variety of healthcare services. So on these last 2 slides, my usual suspects number 1 and number 2, if you've got these types of arrangements, you're just subject to ERISA. You've got to be compliant, and there's not a lot you can do about it. For this next usual suspect, though, there is some planning opportunities about whether to be subject to ERISA or not, depending on how you structure the program. So voluntary group insurance programs can be subject to ERISA or can be exempt. A voluntary group insurance program very typically are things like where you offer a supplemental cancer policy or maybe some kind of supplemental accident insurance. And those types of arrangements are exempt from ERISA if you meet 4 requirements. First, there can be no employer contributions towards coverage. The minute you start contributing even a dollar towards coverage, you've put yourself into ERISA. Second, participation has to be voluntary by the employees. Third, the employer's role with the program has to be very limited. The only things the employer is supposed to do is to allow the insurance company to publicize the program, but with no employer endorsement. The employer can collect the premiums out of payroll, and then the employer can obviously remit those premiums to the insurance company. And then finally, the employer should not be getting any money from the insurance company other than whatever is needed to cover their reasonable expenses. It would be unusual in my experience for an employer to get any kind of payment from an insurance company, but it is permitted in this very limited circumstance. Now, most employers get stuck on that third bullet point, which is why I highlighted that in red. So the question becomes, when does an employer's involvement in the program become too much such that you cross the line into having an ERISA plan? And the problem is, it's kind of squishy. There's not really very clear guidelines around this. And so there have been a lot of court opinions around this, but every judge kind of takes a different view. And so it's really hard for us as legal advisors to say, well, here's this bright line where we think you've crossed it. Some of the things, though, to be careful about are if the contract is in the employer's name versus the insurance company, issuing contracts to each employee individually. The employer assisting its employees with filing claims under that program or helping them with disputes against the insurance carrier, that starts to look bad, like you've got too much involvement. This next one is the one where a lot of people struggle, representing the program as part of the employer's benefit package. And this is really hard, and we recognize that because, of course, in the benefits world, the reason you're letting insurance companies make these programs available is because it is a benefit to your employees. And you do, of course, want to get credit for it. And you do want to make sure your employees are aware that this program is available. So how do you do that without, again, crossing this line? Well, the cleanest way is simply to have the pamphlets available, hand them out, pop them in the mail, and don't do anything beyond that. If you want to talk about the program, though, these voluntary programs, let's say in your overall benefits booklet, then we recommend putting in some disclaimer language like these are voluntary benefits only. We don't endorse the program. This is only available to you as a convenience. Something along the lines to try to distance yourselves a little bit from the program. And then finally, urging or encouraging participation in the program is not a good thing. That makes it start to look like it's your benefit program. I will say on this one, my preference as a lawyer is to try to keep the exemption if you can. And the reason I say that is because I don't like the fiduciary duties that come with this. As you guys know, if you have an ERISA plan, as a fiduciary, you should be making sure you're carefully vetting all your vendors and insurance companies and overseeing them and making sure they're doing what they're supposed to be doing and making sure that the premiums are fair and reasonable, all that stuff, those fiduciary duties that come with insurance programs. And I don't think most employers want to take on that responsibility necessarily for these voluntary programs. So in this one, if you can meet within the exemption, that's what I generally recommend. My last usual suspect is severance, and I will say this is the one that we have the most conversation with clients about. And a lot of clients really resist thinking of their severance plan as being subject to ERISA. So not all severance plans are subject to ERISA. There was a Supreme Court case decades ago that said if you have a lump sum severance payment related to a one-time event like a plant closing, that is not an ERISA plan. Why did the court decide that? Well, they said ERISA governs plans, and that word plan involves some kind of ongoing administrative scheme. And if all you're doing is saying, I'm shutting this plant down and everybody that's getting terminated is going to get a $2,000 payment, I don't really see any kind of administrative scheme with that, right? Very simple, very basic. But once your severance gets more complicated than that, at some point, and again, this is another area that's very squishy, you will cross the line into having an ERISA-governed severance plan. Some of the things that courts look at is the amount and form of the payment. Obviously, lump sums tend to indicate no severance plan versus paying things out over 12 months or 24 months gets you onto an administrative scheme. The amount, if the amount is ad hoc, it's just as every person leaves my company, I just figure it out of my head. There's no scheme there. But let's face it, a lot of companies have a schedule. I'll pay you a week of severance for every year you've been with me. The more you get into that schedule or formula, you're getting into an ERISA plan. Discretion about determining eligibility. So a lot of companies, right, say, well, we pay severance to our full-time employees and only if they're terminated without cause. And then there's discretion. What does full-time mean? What's part-time mean? What's cause? When does that happen? When does the person's termination rise to the level of cause? Once you start getting that like administrative discretion and making those decisions, you pretty much have an ERISA plan. Term of the plan, again, if it's a one-time event, that's better. If it's ongoing, then you've got an administrative scheme, and of course the level of administration. The more your severance program becomes payments over time, and you get outplacement service, and I'll contact the outplacement person for you. And you also get reduced COBRA premiums for 12 months, and this other stuff is happening with other benefits. Every time you layer things on, you've got that administrative scheme that makes you into an ERISA plan. Now, on this one, I've had employers try to tell me, well, Leigh, if I don't write it down, then it's not subject to ERISA, right? And the answer is no. That doesn't get you out of ERISA. Even if you make everybody memorize the rules and you think that by not writing it down I somehow get exempt, that doesn't work. All that means is you have an ERISA program where you violated one of the ERISA requirements, which is that it be in writing. Now, I'll say on this one, I actually prefer, from a legal standpoint, for severance to be treated as an ERISA plan, because if you go back to that earlier slide about all the good stuff that you get under ERISA, I like having all that good stuff in connection with my severance arrangements. Severance can be really litigious, right? People are getting fired and they're unhappy, and they may feel like they're not getting the benefits they're entitled to. But if you have this as a ERISA program, you get a lot of protection in litigation in court. So what do you do if you've got one of these kind of hidden ERISA plans and it's just dawning on you during this conversation that you've got one? Don't worry about it. A lot of times they're really easy to fix the problems. And this is a situation where if you have something called a wrap welfare plan and a wrap summary plan description, they are very helpful. So if you're not familiar with that phrase, a wrap welfare plan is a plan document that wraps around all of the employer's welfare benefits. So the plan will say, me, the employer, offers a welfare program to my employees consisting of medical, dental, vision, disability, life, severance, EAP, wellness. And you just list all your benefits under that document, and now you've got that written plan that ERISA requires. WRAP SPD is the same concept. You have a summary plan description. It's got all the ERISA stuff in there, and it just lists all the different welfare benefits. And then it cross-references a bunch of other documents. So it might say, for a description of your wellness benefits, go look at your wellness pamphlet. For a description of your EAP, go look at that pamphlet. It is perfectly fine and appropriate for an SPD to consist of multiple documents. There's no legal requirement that everything be in one place. The trick with those is the 5500s, and that's where I see the most problem because, as you guys know, if you have a 5500 for your wrap plan, there's the little codes you fill in for each of the different types of benefits, and severance, for example, I think is code 4I, something like that. And if you don't even realize your severance plan is subject to ERISA, you're not filling that code in. Or you're not filling all your insurance schedules out appropriately. So that's the one that you need to spend some time on to try to make sure you get right. With that, I am going to turn it over to Kathy to talk about record retention.
Thanks a lot, Leigh. As Leigh mentioned, what I'm going to be talking about today is the whole world of record retention for all of your benefit plans. And really, there's kind of three statutes that we have to deal with, and they're listed here on the screen. There's first ERISA Section 107, which concerns about what data do you need to keep for all the information that is reported on your 5500. Next, there's ERISA Section 209, which is all the data that you need to substantiate and support a retirement benefit calculation. And then there's finally Internal Revenue Code 6001, which applies to all taxpayers, but in the context of a qualified retirement plan, is to demonstrate that your plan satisfies all those qualification requirements. So let's start with the 5500 data. The statute actually requires the employer to maintain any report, record, vouchers, worksheets, anything that sort of underlies the information that is reported on the 5500. And it applies to not only the plans that actually do file a 5500, but it also includes all those plans that are exempt from filing a 5500. Because they're a small plan, they have less than 100 participants at the beginning of the year, they are unfunded or they're fully insured or a combination of the two, and they are not a MEWA. Also, too, it's important to know that when you electronically file your 5500, one of the requirements with that electronic filing is that you also manually sign the very first page of the 5500. And that is going to be posted along with a copy of the 5500 on the Department of Labor's website. So don't forget to actually manually sign your form. Also, exactly what kind of format do you need to sort of corral all of this information? Well, in 1982, the Department of Labor issued an opinion letter, and there it basically said, recaps or summaries of this 5500 data is not acceptable. So that requires that you actually maintain copies of all of the health claims in a medical plan or vouchers or, whatever. And the reason why for this strict requirement is that the statute wants you to be able to maintain the data so that it can be verified, explained, clarified, or checked for accuracy and completeness. And if you're only looking at a summary of claims received by a plan, you're not able to do this kind of examination. So how long do you have to keep all of this information? Section 107 says you need to keep the information for 6 years after the filing date of the 5500. But as everybody knows, the 5500 is due 7 months after the end of the plan year, and oftentimes employers take advantage of the fact that they can ask for an extension of up to 2.5 months. So I think as a best practice, it's really good to think about keeping these 5500 records for a period of 8 years. So that definitely covers all the extensions to file your 5500, plus gives you a few months cushion. So I think that that's a good rule. Next, we're moving on to Section 209, which is kind of a big section in that it requires an employer to keep all of the data that will substantiate or back up a retirement benefit plan calculation. So just keep in mind to think of if a participant comes in and says, I think I'm owed more money, you need to be able to provide the data to show why your calculation is correct. So this would include the compensation and the service records for that employee from their hire date. And also, too, that, as I'll discuss later, proof that the benefit was actually paid. So the statute also says that you need to keep the information that is going to be reported on participant statements about their accrued benefits. So for all retirement plans, you need to keep information about what is their total accrued benefit, what is the participant's vested percentage, if they're not fully vested, the date they will become fully vested. If the pension plan has an integrated formula, exactly, keeping the data to support that disparity calculation. Also, if the formula is an offset, the details to be able to substantiate the offset. Now, if your plan is a defined contribution plan, you also are required to keep, as of the most valuation date, the value of each of the investments which holds account assets. And if your plan also offers employer stock as an investment option, then the value of the assets held in employer stock. So what exactly do you have to maintain? Well, first of all, sort of the first cut is what the IRS thinks of as permanent records. And it's kind of like the documents that under which the plan operates. So for retirement plans that are individually designed, this means your signed plan documents and amendments, also dated ERISA 204H notices, your IRS determination letters, and if you've purchased an annuity contract to satisfy any of the plan's liabilities, copies of those annuity contracts. An ERISA 204H notice is the written notice that you have to give to participants in defined benefit plans and money purchase plans if an amendment is going to significantly reduce future accruals. And these notices have to be given out in general 45 days in advance of the effective date of that amendment. So I was recently helping a client wind up the termination of a single employer plan, and unfortunately the PBGC audited just by random this little plan. Now this plan had been frozen about, I think it was 12 years ago. And one of the things that the agent asked for was a copy of that dated ERISA 204H notice. Now, while we could find the 204H notice, unfortunately, it didn't have any kind of date on it. And so we had to convince the agent that it was proper because, since in the ensuing 12 years, the plan had received, I think, a couple of determination letters from the IRS. So we were able to get over that bump. If your retirement plan is a pre-approved plan, like a prototype or a volume submitter, you need to maintain copies of all of the signed adoption agreements, the amendments, the base plan document, any appendices to those adoption agreements, and of course the IRS opinion letters or advisory letters, which is very similar to like an individual determination letter. If the plan covers any union people, you need to maintain copies of those collective bargaining agreements, also the plan's trust agreements and any amendments to the agreement, and also a copy of the trust statements because this will be helpful to document of when a benefit was actually paid. Another portion of the permanent records would be the plan's SPDs or Summary of Material Modifications, SMM. And this is kind of tricky because you need to keep a good record of what SPD version was distributed and when and to whom. And also in the world now where oftentimes SPDs are available electronically on the employer's intranet, you have to keep very careful records of exactly what version was posted when on the intranet so that you can prove if somebody says, I pulled a copy of the SPD in 2016 that you're able to replicate exactly what that employee was looking at. So what kind of data do you need for benefit calculations? On the IRS website, they have a little listing of these are the things that they want you to keep. So it's census data, it's account balances, contributions and earnings, loan documents, and also recently the agencies have been focusing on hardship distributions, that you have adequate documentation to show that it was a valid hardship withdrawal. Also compensation data, participant statements, and I think also it's a good practice to include signed copies of the participant benefit distribution election forms with spousal consent if necessary. If you have a defined benefit plan, I think it's very important to keep copies of the worksheets that actually cranked out the benefit amount. And again, signed benefit distribution election forms with spousal consents. Also death certificates to substantiate a proper death benefit payment. I know that most employers require a copy of the death certificate before paying a death benefit, but in this plan that I was helping through the PBGC audit, there had been several participants who died during the interim of when the plan was being wound up. And so one of the things that the agent had asked for was copies of death certificates. And we didn't have that because for the dozen or so people who had passed away in the interim, they were just, we knew of their deaths because of the results of professional search firms. And also, we had to, finally the agent was satisfied by giving the Social Security numbers of the deceased participants, and then she looked up on her death benefit list to verify that these people had actually died. So also, too, as the agencies are focusing more and more with large defined benefit plans as to whether or not they're actually paying out vested terminated participants, a lot of times these people are hard to locate because they might have worked for you 10, 15 years ago. So keep good records about your diligent searches for these missing or non-responsive payees, the people who get their benefit distribution election package but for some unknown reason just don't reply. So, this is a lot of information that employers are required to keep. So one of the things to keep in mind is organize your permanent records for easy access and readability. One thing I was reading about, agents are often frustrated because when they come to do an on-site visit, the plan documents are in disarray. They're not in order, but there's not signed copies. And just keep that in mind, have it very neatly organized. Also, if the information is stored electronically, then it has to be easily accessible and printable. And also, I guess the agent has to be able to manipulate the information to be able to print out the information that he or she is concerned about. So how long do you have to retain all this benefit calculation information? Well, the IRS says until all the liabilities are satisfied and the plan can no longer be audited. Well, how long does an IRS agent have to audit a plan? And the usual rule is 6 years after the tax return is filed. But in case of fraud, which is if the underreported income is more than 25% of the gross income initially stated in the return, then the IRS can reach back 6 years. If we're looking at employment tax records, and that would be all wage and annuity and pension payments, the rule is that the IRS can look at the prior 4 years. So I think for a best practice with regards to employment tax records, it would be good to keep those records for 5 years. So how long should you retain in case, of participant lawsuits? They're unhappy with the amount of their plan benefit, and so they file suit. Well, unfortunately, there is no statute of limitations listed in ERISA for purposes of benefit claims. So generally what happens in this situation is that courts will look to a similar state statute of limitations, oftentimes to the statute of limitations applicable to a breach of a contract. And as Leigh had mentioned earlier, recently in the last few years, the U.S. Supreme Court has actually upheld a plan's internal statute of limitations as long as it's reasonable. And I think that they came partly to this decision in that, ERISA's reliance on the plan's written terms and 3-year statute of limitations have been upheld. So the next tricky question, though, is when exactly does that statute of limitations clock start? And here, unlike where a plan document can actually set the length of a statute of limitations, a plan document cannot define when that clock starts because that's an issue for federal law. And it becomes kind of tricky because it depends on what benefit type is at issue and also what has been the precedence in your own jurisdiction. So as Leigh explained before, it can be after the claimant has exhausted the plan's internal claims and appeals procedures, then the clock starts then. But there have been some odd results. I found a couple of cases where in the context of a defined benefit plan where the issue was the validity of an amendment that reduced this particular participant's benefit, the court held that each time that the plan paid a monthly benefit to this participant, that started a new statute of limitations because the dispute was about the amount of the benefit. Similarly, there was a disability case that had the same result, that a new statute of limitations starts with every monthly payment. So it can be tricky. Next, let's move on to Code Section 6001, which is sort of the broad overview of how do you demonstrate that you have complied with all the qualification requirements for your plan. And one of the things, again, as I mentioned, the service and the Department of Labor is focusing on, did this plan timely pay its benefits for vested terminated participants? And there are actually two mandatory distribution dates within a retirement plan. And this first one, 401A14, is often overlooked by record keepers. But it's when the deadline is actually no later than the 60th day after the end of the plan year in which the latest of the following occurs. The participant attains normal retirement age, the 10th anniversary of when they enter the plan, or the participant's termination date. Now, if you miss this deadline, how you can fix that is option number one is you actuarially increase the normal retirement date to the delayed start date and start paying that bigger benefit. Or you start paying the benefit that would have been payable at age 65, but plus a lump sum, though, that equals all the missed payments increased with interest. And, of course, the second mandatory distribution date is the age 70.5 minimum required date, which depends on whether or not the participant is a 5% owner or is not a 5% owner. So what kind of data do you need to keep for Section 6001? Well, the first thing that popped into my mind was, all of the plan's non-discrimination test results and the supporting data, and that could include such things as, your control group data, so that you could demonstrate, yes, I was testing this plan with the right employee group as the pool. Also, it could be various things, such as your direct rollover election forms, your benefit distribution forms, your qualified joint and survivor notices and waivers, which is becoming more complex because they must show relative value of the different optional forms. Also, your quadro, your qualified medical support child orders for health and welfare plans, and also the checklist for those procedures. And finally, I just wanted to touch upon ERISA fiduciary liability concerning plan investments, because over the last several years, lots of plans and employers have been taken to court because of the alleged unreasonable fees that they have charged to their participants. So it's very important to keep the committee minutes, for example, fee benchmarking studies and the rationale for decisions regarding new providers. As a fiduciary, also they have to look at the investment fund review and monitor the performance of those funds. If any time that there is a change in the investment fund lineup, I think it's very important to include all the documentation of why that fund was made and why the new fund was chosen. And also, again, your ongoing monitoring of service providers' fees and their performances. So here it makes it easier, at least that ERISA Section 413 does provide a statute of limitations for fiduciary breaches. And it's 3 years after the earliest date a claimant had actual knowledge of the breach, or 6 years from the last act that was part of the alleged breach, or if there was fraud or concealment from the date of discovery of the breach or the omission. So, of course, the challenges in these records retention and the mergers and acquisitions, the IRS position is that the buyer has to get all of the permanent records for the acquired plan. So that oftentimes is very difficult if the target didn't have good records. So what are the consequences of inadequate record retention? And it's a burden of proof shifts from the claimant to the employer, when usually if the records would be in good order, the burden of proof remains with the claimant. So, for example, this was a defined benefit plan where a participant terminated in 1979, and he was due a normal retirement benefit paid 25 years into the future. So since he had terminated, his plan had actually been sold twice. The employer was sold to two other successors who always assumed the defined benefit plan. Eventually, though, the plan was terminated, and at that time, he elected a lump sum over an annuity, but unfortunately, the lump sum was never paid to him. So after making numerous calls, because he had to face the unfortunate, experience of having to find the right HR department because his employer had been sold several times, he finally connected with the right person. And he was told, no, you're not entitled to a lump sum. You must be entitled to an annuity when you reach age 65. So he patiently waited until he turned age 65, but again, no benefit payment was made. And so he inquired again, and then he was told, well, you're not entitled to an annuity because we have no record that an annuity was purchased. You must have been receiving a lump sum back when the plan was terminated so many years ago. So he finally sued. And the employer had to pay him his benefit because they had no records that the lump sum was ever paid. And so that was the consequence. You know, the employer had the burden to prove that the benefit actually had been satisfied, and they could not do that. And so they had to pay the benefit. This also came up in the context of how much employer contributions were owed to a union multi-employer plan. And here the trustees had sued the employer for more contributions because they said that the employer underreported the number of covered employees. But because the employer had no records, the employer couldn't demonstrate that the amount of the contributions that he did pay in the past were justified. And so therefore, the court held, because Section 209 requires that the employer maintain such records, he had to pay the additional contributions to the trust. So I think sort of best practices with record maintenance, it's a lot of data that you're dealing with. You have off-site storage. You have to have in the contract that the employer must have continued access after that relationship ends. And this oftentimes comes up in the context of record keepers for defined contribution plans. You know, the plan is audited. The auditor wants to look at something 3 years ago that was with a prior record keeper, and the prior record keeper says, we have no obligation to provide you with that data. And so that leaves the employer in a very bad spot. Also, just be very mindful of all the technology upgrades and the changes in how you can store records. Also, with electronic records, be very careful about monitoring and assuring the continued security of your records. And finally, always keep in mind to organize all of this data so that it can be quickly found, manipulated, and also to be able to print such information. So with that, I'm now going to turn it over to Ryan.
Actually, Kathy, I'm going to step in and announce the CLE code today for those who are interested in CLE credit. We will go ahead and move to the polling question. If you are seeking credit today, please enter the following code. That code is 6YCO3. Again, that's the number 6, Y as in yellow, C as in cat, O as in octopus, and the number 3. I'll leave this open briefly. One more time, that code is 6YCO3. And for those of you seeking credit in Kansas, New York, or New Jersey, in addition to typing in the polling question, you will also need to complete the attorney affirmation form immediately following the program. A copy of that form can be found on the resource list widget. And for everyone seeking credit today, please note that CLE certificates of attendance will be distributed to eligible participants in approximately 6 to 8 weeks after this webinar. Those will come to you via email. And now we can go ahead and turn the presentation over to Ryan. Thank you.
Thank you very much, Kayla. I'm going to be talking today about what to do when a MeToo complaint comes in the door. For purposes of our discussion today, we'll talk about kind of a specific MeToo complaint, which I would define as something that comes to the company's attention via social media. But note that all of these points largely apply to all complaints of sexual harassment in the workplace, given the current environment. So by now, I think we're all familiar with the MeToo movement. It's existed in some form since around 2006, but it really exploded in popularity in October 2017 in the aftermath of the Harvey Weinstein allegations. It was popularized in a tweet by Alyssa Milano, where she stated that she was a victim of sexual harassment and invited all other victims to come forward using the hashtag MeToo. Obviously, it's become a global phenomenon, and it's really been used by victims of sexual harassment for two reasons. One, to show kind of a strength in numbers, to overcome the fear, the anxiety, the shame of being a victim of sexual harassment. And then second, to call attention to the breadth of this issue, to show that it really is a systemic issue in our society. For employers, MeToo raises some very specific issues because of the underlying premises. On the screen right now, we have a couple of those premises, and there's a couple that I want to draw attention to. The second one there on the list is that companies, including both legal and human resources employees, yeah, they'll conduct investigations, but what they're really interested in doing is just protecting the company, not really getting at the source of the truth, papering over the record to show they did an investigation, and then just moving on. And the second important premise is this fourth bullet point, which effectively says that people coming forward with MeToo allegations should be presumed to be telling the truth. That, why would someone make this up? If they're saying it, it generally should be presumed to be true. And both of those points, raise difficult issues for employers in the workplace. Because we have to do thorough investigations. We have to act based on facts, not solely on allegations. So we'll talk a little bit today about how to deal with those issues. Just real briefly, the scope of the MeToo movement has obviously been in the news in the last 8 months, so I don't want to cover that ground too much. But just note that you have this small universe of employees, or excuse me, this small universe of congressmen. And just within those 500 or so people, within the last 6 months, 9 of those individuals have resigned their jobs because of allegations relating to MeToo. There was a week in December where 3 separate congressmen resigned their office based on sexual harassment type allegations. So it's definitely still a widespread issue and one that employers have to confront. As an employer, we often are in a tricky space. On one hand, we need to be sensitive to these kind of allegations, and we do have a legal duty to conduct investigations into the allegations. On the other hand, we can't fall victim to the sometimes mob mentality that can prevail on social media. So the way to walk the middle road between not taking complaints seriously and just assuming they're true is to conduct a prompt and thorough investigation. The first question then that we need to ask when we receive notice of a MeToo type complaint is whether an investigation is even needed. The simple answer to that is that a MeToo allegation is no different than any other kind of allegation that comes into human resources or comes into an employer hotline or comes into the legal department or comes to any manager really. Anytime management becomes aware of a complaint, a workplace complaint of harassment, the company has to do an investigation. The kind of sometimes anonymous nature of reports can make it more difficult to conduct an investigation. It can impact the scope of the investigation. But what it can't do is give the employer an excuse not to investigate at all. The rule under the federal civil rights laws and most state laws are that if a manager is aware of a harassment report and does nothing, that manager's knowledge and failure to take action will be attributed to the company. So once you've decided that you are aware, once you determine you're aware of an allegation, you need to conduct an investigation. The next question to figure out is who will conduct the investigation. And to this question, there are some considerations that apply to all investigations, but there are some that are specific to MeToo type allegations. Of course, you want to avoid any kind of conflict of interest. So neither the accuser nor the accused should be involved in any way in conducting the investigation. So if it's an investigation of the legal department, then the legal department should probably take a step out. If it's an allegation against a human resources employee, HR should probably step out. But even beyond the conflict of interest issue, there are a number of other issues that really are somewhat unique to MeToo and harassment allegations. And it's that last bullet point, the potential media interest that we really need to consider. I spoke a moment ago about this presumption that the company is just in it for themselves and they're going to take whatever action they need to protect themselves. So with that in mind, it often does make sense to elevate an issue outside the internal company investigation ordinary routine. So, rather than having an internal investigator do it, you can have an outside lawyer do it. But in some cases, even the outside lawyer, if it's the law firm that the company uses for all other issues, again, there's still going to be a question of whether the law firm is just covering up for the company. And because of that, kind of a cottage industry of credentialed independent investigators has sprung up and really expanded in the last year. And those folks really can be as independent as you need them to be to avoid any allegations of impropriety in the investigation. You know, the ordinary rules apply. The more senior the allegation, the more senior the accused, then the more likely you want to have an outside person do it. The more serious the allegations, the more likely you want to have someone outside doing it. One advantage of using either an outside lawyer or an independent outside lawyer is the ability to retain attorney-client privilege on the investigation. When we conduct investigations, generally our notes are privileged, and we'll produce ultimately a thorough, detailed report at the end of the investigation that's not privileged, but our underlying notes can be privileged, which can be useful for conducting very thorough investigations and knowing that your notes aren't going to be part of a record in discovery later on. So you've determined that you need to conduct an investigation, and you figured out who your investigator is going to be. So the next question is to figure out how to proceed with the investigation. Certainly an in-depth discussion of effective investigation techniques is something we could discuss all day, but there are a few specific points that I want to raise that can be highlighted or extra important in MeToo type complaints. The first one is you want to give the accuser who's coming forward an opportunity to vent. These allegations and the subject matter is a very sensitive one. So employees may be uncomfortable coming forward, and because of that, you have to really be inviting and allowing the employee to tell, generally it's a female, her side of the story before you get into asking specific questions. So you allow the employee to gush, to come forward and tell them everything that they need to get out that they've been holding in. And you got to let them kind of get through that process before you really go forward with the investigation. But once you do that, once you let the gushing out, it's incumbent on the investigator to then ask all the necessary follow-up questions to really get at the facts. So if, for example, an accuser comes forward and says, just something generally like he's always sexually harassing me, then the investigator needs to ask, what do you mean by sexually harassing? Is it verbal conduct? Is it touching? What are the specific facts? Because that will obviously be important going forward in conducting our investigation and ultimately determining if there is discipline to be issued, what that discipline will be. Another issue in MeToo complaints is that an accuser is often reluctant to participate. Sometimes you have other employees coming forward and reporting the incidents, but the alleged victim doesn't want to come forward. And there's two things that you need to do in that case. The first one is you really have to emphasize that it's the company's goal, it's the company's intent to prevent any kind of harassment in the workplace. It's what we want to do. It's an effort to make our workplace the best and safest place it can be for all employees. And then the second point to raise is that the company does have this legal obligation to investigate. We have a duty, now that we are aware of an allegation, to come forward and investigate. And so you do have to push the employee a little bit to come forward, even if they're a little bit reluctant. And finally, you have the issue of what happens when the accuser is anonymous. In some cases, we have anonymous Twitter accounts, we have anonymous hotline calls that raise these allegations. That obviously makes investigation a little bit more complicated, makes it a little bit more difficult to determine, who's supposedly the victim, what supposedly happened. But in those cases, the best you can do is, interview all around the accused individual. So if it's a manager, ask all the manager's direct reports, ask the manager's coworkers, and you do the best investigation that you can under the circumstances. One other important consideration when figuring out how to conduct the investigation is the extent to which you want to try to maintain confidentiality. Ordinarily, investigators like to limit the discussion of the topics under investigation. I know certainly when I'm conducting an investigation, I appreciate having as blank a slate as possible to limit the gossip that's going around as much as possible. But in these MeToo allegations, there are other considerations that need to be raised. If you ask the accuser not to discuss the allegations that are the subject of the complaint, it can be perceived as part of an attempt to silence the accuser, which is something that's underlying the whole Me Too movement to begin with. So you have to determine if there is a very specific targeted need for confidentiality. Something where the employee says something very specific happened and you need to follow up with an immediate interview of another employee and you need to keep it under wraps until you speak to that employee. If you don't have that very specific need, then ordinarily it probably doesn't make sense to demand confidentiality on the part of the accuser. Also note that there are special considerations if, for whatever reason, the accuser leaves employment and there is a severance agreement entered into. There are now tax considerations of including a confidentiality clause in a severance agreement that covers a Me Too allegation. So that's something that you'll want to discuss with your legal team before entering into any kind of confidentiality provision upon termination of employment. Perhaps the biggest challenge in Me Too and sexual harassment investigations is figuring out what to do when you have a he said, she said allegation. You've conducted a thorough investigation, you've interviewed all the potential witnesses, you've looked through emails, you've looked at camera footage, and you're left with two diametrically opposed accounts. And so the question is, what do you do when that happens? The good news is that you are entitled to act based on your conclusions, even if it is a he said, she said. We often compare this to what juries are asked to do every day. One person says the light was green, one person says the light was red, and the jury has to decide which one to believe. As an investigator, you're entitled to make those conclusions as well. If you're going to do that, of course, you want to document the basis for that decision. And so let's talk about some of the factors that you can consider when determining who to believe in the he said, she said environment. Certainly the biggest one, if it's present, is the number of allegations against the accused. This would be the Bill Cosby factor. I'd like to believe that you wouldn't have an employee with dozens of harassment allegations against him or her before the company acts. But if you do have those, then obviously that's a factor to consider. Even two allegations against a particular employer, if there's no apparent connection between the two employees that are making the allegations, those are things that corroborate each other. So if two women come forward with complaints against a supervisor, the women don't know each other, but they make similar allegations against the supervisor, that's a factor that you'll need to consider in your investigation. Certainly you'll want to determine the motives for dishonesty from either party. Is this an employee who is on the verge of termination and now all of a sudden they're making a harassment allegation for the first time? It doesn't mean the allegation is false, but it certainly makes us as investigators a little bit more skeptical. You'll want to check into the consistency of each employee's accounts. Do they have a consistent story, or is the story constantly shifting and changing a little bit? That's why it's so important to follow up with those factual questions to get a full account of what the accuser and the accused claim happened. That way you can always go back later on and ask similar questions later and check the consistency of the stories. You want to look at the employment history of the individuals. If you have a 30-year employee who has a sterling record and all of a sudden she's making a complaint for the first time, that's something that you're going to want to take a little bit more seriously. Vice versa, if you have a 30-year supervisor who's never had any kind of allegation against him, that's something that you can factor in as well. Again, these aren't decisive factors, but things that you're called upon to do as an investigator. Finally, you look at the person. Do they appear credible? Do they appear nervous? Do they appear defensive? Do they refuse to make eye contact? Again, these aren't open and shut cases because this is very serious stuff, so it wouldn't be shocking to have an employee be nervous or defensive. But again, it's something that the investigator can consider when conducting the investigation. At the end of the day, if you feel like you can't make a determination, you'll still want to document the investigation and at the very least put a strongly worded letter into the file of the accused. That puts him on notice that the company takes the issue seriously. It can warn him that any corroborated allegation could lead to termination. It can warn him that if the company learns of any new evidence, it can take action against him. and it can help show if there is any litigation down the line that the company did take things seriously and investigated thoroughly. Ultimately, the goal is to get this right, to have a process that protects the company and its employees. Yes, legal liability is important for businesses, but it is more than that. You want your employees to be in a workplace where they can be free from harassment, where they can be free to flourish and thrive. And quickly, thoroughly investigating allegations is a good way to help do that. And I will note just that final bullet point in passing. We're only now just starting to see a little bit of a backlash to the Me Too movement. This sense that there's a rush to judgment, and that innocent victims, the people who are accused are actually innocent victims of lies. And I think in the years coming forward, we'll see more claims from employees that are terminated as a result of harassment investigations, coming back and accusing the company of failing to conduct thorough investigations, and the employees getting railroaded. It remains to be seen how broad that is, but having a good investigation plan in place and conducting the investigation quickly and efficiently is a way to avoid those kind of claims. With that, I will turn the presentation back over to Leigh.
Thank you, Ryan. That was very fascinating. I'm glad I work with like 401k plans and don't have to do your job. So we had one question that was asked relating to the hidden ERISA plans, and it was a really good question. So the question said, when you use a vendor for insurance and offer some benefits that have employer contributions and some that are voluntary, can we encourage participation? And this is a great question because this comes up a lot, right, where you've got an insurance company and you have a combination program. Life insurance is a great example. The employer covers basic life insurance of one-time salary, and you, the employee, can purchase additional life insurance on top of that, completely voluntary, and you pay for the whole thing. So what's that type of program? Well, typically that type of a program, the whole thing is going to be an ERISA plan, because that voluntary life insurance part is going to be embedded in the group policy that's given to the employer, and that you, the employer, you've negotiated the policy and you've negotiated eligibility, and you may have been negotiating premiums, and you kind of had your hands over the whole thing. So in that type of situation, that voluntary insurance is going to be ERISA, and if you want to encourage people to participate, help yourself. That's totally fine. Distinguish that from, let's say, a life insurance program where you're sitting with your life insurance vendor and all you're doing is buying a employer-paid policy, right? I'm not going to give people the ability to buy supplemental life insurance, but the insurance vendor says, hey, I've got some other types of insurance products that your employees might be interested in. I've got some automobile insurance and some homeowners insurance and some supplemental cancer insurance. And would it be okay with you, company, if I, publicize these and you can do the premiums and remit those to me? So in that type of situation, those additional policies that the insurance company wants to, publicize to your employees, those, again, and it's just my preference, I would try to stay outside of ERISA, have that very limited involvement, don't encourage participation in those, so you can get out of any ERISA duties for those kind of supplemental ancillary insurance. I hope that answers that question. If there are any other questions before we finish up, please hit that Q&A widget at the bottom of your screen, submit it to us, and we'll get back to you in an email. And other than that, if you have CLE questions, please contact Kayla Hooven at the email address listed on the screen. And we are finished for today. And everybody, please have a wonderful rest of the day and rest of the week. Thank you.